Today's webinar is Navigating the European Accessibility Act Requirements and Best Practices. My name is Bethany Servin, and I work in marketing here at UsableNet. So your panelists today, I am very excited. We have Sophie Goossens, who is a partner at Reed Smith, Tom Gates, who is a senior associate at Reed Smith, and our own Michele Lucchini, who is Vice President of Product Management at UsableNet. Once again, this webinar is produced by UsableNet in partnership with Reed Smith, and I'm actually going to hand it off to Sophie to tell us a little bit more about Reed Smith.
Thank you, Bethany. Hi, everyone. It's a pleasure to be here. Thank you so much for having us. Tom and I are lawyers at Reed Smith. Reed Smith is a full-service law firm with 31 offices across the world, in the US, in Europe, in the Middle East, and in Asia. We're both working in the entertainment and media team with a practice that is focusing overwhelmingly on digital and online media. So we work with websites, apps, video games, software developers, streaming services, advertisers, brands on all types of issues from liability, copyright, privacy issues, and of course, more and more regulatory issues. We've seen how digital regulation has grown massively over the past few years and has extended its reach to many different topics, including child safety, AI, content moderation, and now recently accessibility. Our practices have grown to cover all of these topics. We have been working very closely, of course, with other lawyers in the business, including our partners in the US. Some of them have been the key advisors to household names for many years. And now we are seeing this topic of accessibility really becoming more of a focus in the EU. And that's one of the reasons why we're very happy to be here today to present alongside UsableNet and hopefully to explain to you how to stay on top of this issue. Over to you, Michele.
Yeah, thank you, Sophie, and welcome everyone. Today's agenda is quite rich. We'll start with an overview of the European Accessibility Act. Then we'll do a little deeper dive around the scope of the European Accessibility Act. We'll talk about the key compliance deadlines, the legal accessibility standards that are associated to the European Accessibility Act. We'll also mention which are the exceptions, exemptions, penalties for non-compliance, and I'm sure that this will be very interesting to everybody. We'll talk about the best practices for achieving accessibility, which are founded on over 2 decades of experience and experience that both UsableNet is sharing with Reed Smith. We'll also present a case study, so trying to better elaborate on a real-life scenario and how Touchland has accomplished the conformance. And then we'll go through the best way and which are the steps that everybody should take in order to implement an accessibility roadmap and an accessibility program. And we'll conclude with the key takeaways, and we'll make sure to leave some minutes for a Q&A. Excellent. So moving on, the biggest question probably is why businesses should prioritize accessibility. And at least based on our experience at UsableNet, we see many different driving forces. One is definitely a rooted ethical responsibility on promoting a healthy inclusivity on the digital property. Another aspect is, which is more, let's say, present in the retail space and the e-commerce, is to make sure that we are reaching as many people as we can. So expanding the customer base is also one of the driving force. There are also on the ethical side companies that, because of their statement, because of their mission, wants to be very active in promoting something to facilitate diversity and accessibility. And last but not least, we are still seeing that a lot of initiatives around accessibility are starting from the legal threat, and the implementation of an accessibility program is mainly to mitigate the legal risk. Turning also to Reed Smith to see if they have any comment or wants to share any experience they had on this.
Yeah, certainly. So I think for us, from a legal perspective, we are really seeing regulators, and we'll come on to this, getting much tougher on accessibility in the EU. As Sophie mentioned, this is something that our colleagues in the US have been seeing for well over a decade, but it's now becoming a global issue, and it's something businesses need to be alive and reactive to. Otherwise, they could face legal implications for not being. So I think if we just move to the next slide, we can get a bit more specific on what we're going to talk about today, the rules on digital accessibility in the European Union, because that is really the driving force behind this push from regulators in the EU. So just to give you a bit of background on what the EAA is, I'm not going to go into huge detail because it's been around for years. It's been a very long journey to get here, but it is coming into force next year. And the purpose of the EAA is to, as it says in the Act, the Directive, to contribute to the proper functioning of the internal market by approximating the laws, regulations, and administrative provisions of member states regarding accessibility requirements for certain products and services, by in particular eliminating and preventing barriers to the free movement of products and services arising from divergent accessibility requirements in member states. So the idea that across the European Union, there'll be a harmonized approach to how accessible products and services are offered. So the first thing to point out here, for those of us who aren't familiar with EU laws, is that this piece of legislation is a directive. So that means that it's essentially a guide for each country, each member state in the EU to implement it into local laws. So the text of the European Accessibility Act does not apply automatically. It needs to be transposed. And what we're seeing, and what we have seen in the last year, is that each member state has taken a very different approach as to how it has adopted those rules. Some have adopted brand new ones, like Ireland, and some have amended over 20 existing ones. But what is quite interesting is that the EAA is a legal floor, so it can be built upon. So the rules in one country could, in theory, be stricter than the rules in another country, which is why there's a slight irony in the reference that I just read out in the EAA to eliminating barriers caused by divergent accessibility requirements, because the EAA in some ways actually facilitates this. So not a great starting point. Already a bit of confusion for businesses operating in multiple EU countries. Which rules do you comply with? How do I know if I am complying? So we'll cover that shortly. But if we just go into the next slide, we can think about who and what the Act applies to. So the most important thing to think about when you're thinking about the EAA is, does it actually apply to me? Do I even need to? And if it does apply to me, which of my products and services are in scope? So thinking specifically about the digital and online space, some of the key sectors and services affected by the EAA are set out here. So any consumer e-commerce service, so the buying and selling of goods, video streaming platforms, ebooks, just to name a few. But where does it apply? Well, it applies where those services that I've just mentioned are made available in the EU. So your company and your organization does not need to have an establishment or be employing individuals there, be based there. You just need to be offering and making available that service in the EU. And it's a similar story for products as well. It applies to manufacturers and importers of products who make available these products in the EU. Again, they do not have to be based in the EU. So you can really see how wide the EAA is potentially. It has extra territorial remit, and businesses need to be aware of this, even if they don't have a particular presence in the EU. Next slide, please. So if we've decided that the EAA does apply to us, that our organizations in scope, our products, our services are in scope, what do we actually need to do to comply? Well, the first thing to consider is which rules do I need to follow? Because as I said, the EAA is a directive. The text of the EAA does not apply directly. So then you need to look at the laws of the correct country, the correct member state, to work out what you need to do to comply. And Sophie's going to talk a bit about how we work out which country's rules we should be following.
Thank you, Tom. So as you mentioned earlier, the first criteria is really to see or to ask yourself whether you have eyeballs in the EU. So then if you have eyeballs in, especially I'm talking here and I'm thinking about digital services, which is the focus of today's session. So any website with people that are able to access it and see it in the EU would be in scope. And as Tom mentioned, the establishment in the EU is irrelevant with respect to the applicability of the EAA. However, there is a difference between having and not having an establishment within the EU when you look at the countries whose rules are going to apply to you. So imagine a website that is available in all 27 member states of the EU. The key question here will be, do I need to follow the requirements of France or Germany, or do I need to follow the requirements of all 27 member states? Because my website is available in all 27. And that's where having or not having an establishment in the EU can make a big difference. Having an establishment in the EU likely means that you can follow the rules of the country where you are established. Of course, the website needs to be offered by the entity that is established in the EU. So it has to be the same entity that is delivering that online property to users. But if that's the case, then it is likely sufficient to abide by the rules of that country of establishment. In the absence of an establishment, however, the rules go back to the default position, which is that the online property would have to comply with 27 different sets of rules. I mean, that sounds a little bit alarming, but Tom and I were having a discussion about this earlier, and we concluded that it is probably a little bit less alarming than it sounds, just because the requirements themselves are likely to be quite similar. However, the way they will be enforced can be very different. And I think we'll discuss that a bit more. So it's more in how it will be enforced, the number of agencies and bodies you'd have to deal with, and the risk, of course, can be very different from one country to another.
So coming back to that point on compliance and knowing which rules to follow, we'll talk more in a moment about the standards that are likely to be expected of us in this space. And it's something that UsableNet is very familiar with. But in summary, the good news is that largely we're expecting compliance to be measured against existing global and EU standards, which means that your development teams and your web teams are probably already fairly familiar with some of these standards, and it shouldn't be a huge learning curve if you're already making efforts to comply with other accessibility rules, or whether you comply with them voluntarily. So it might mean that you are somewhat already on your way to compliance. We'll cover the specifics of what this looks like in a moment, but it's worth also noting that much of the EAA isn't prescriptive. It's very principles-based. There's 4 principles, again, which we'll cover, which of course allows the standards and expectations to develop as time passes, as online services evolve, and as technology becomes more sophisticated. Next slide, please. So we'll get into the detail of compliance shortly, but if we've established that we need to comply, that our products or services need to comply, and we know which country's rules apply, when do we need to comply by? So there are two key compliance deadlines for the EAA. From the 28th of June, 2025, all services that are in scope must comply, and all new products put onto the market or made available on the market in the EU must comply. If you have an existing product which was available prior to this date, you'll have a 5-year transitional period where that product does not need to comply until the 28th of June, 2030. That being said, there are a few exceptions to these rules, which I won't cover in detail today, but there's a couple if we just go to the next slide, which I'll talk about. So here are a few exemptions and exceptions. It wouldn't be EU law without them. So the first one to note is that there is an exemption from compliance with the EAA if your organization would otherwise have to comply, but it would be deemed a micro enterprise. And you can see the definition on the screen there. Secondly, disproportionate burden. There are some very limited exceptions to the accessibility rules where they would result in a disproportionate burden on the economic operator, or they would require a fundamental alteration to the product or service in question. Going on to the third example here, as would follow logic, footage, articles, archived content, and from a digital perspective that has been produced before the rules come into force would not be required to comply with the rules. So that's provided that you don't make any changes to them after that date. So for example, apps that haven't been updated after that date, or archived websites, certain online mapping services, they will not need to comply with the rules provided no changes are made to that content. And finally, the transitional period I just mentioned, there are some additional exceptions for products and services that are offered in hybrid together, where you are offering a service and you are lawfully providing a service alongside a product that was compliant before the deadline applied. So that's just 4 examples. There are a few more. Michaela and I were discussing this week. There is a fair amount of generosity within the EAA regarding compliance and who needs to comply. So we do think that the wider exceptions that are available will be interpreted rather narrowly. So if we just go into the next slide, we've talked about how we comply and when to comply, but what happens if we don't comply? Well, going back to the fact that the EAA is a directive, it doesn't set out specifically what will happen if you don't comply. It's left up to each member state to determine effective, proportionate, and dissuasive measures. Now, this makes Sophie's point earlier about which countries' rules apply even more important, because as we're starting to see, some countries are introducing much stricter fines and enforcement actions than others. So Ireland, for example, as you can see here, for the most kind of egregious breaches of the local transposition of the rules, that can result in a prison sentence. Some countries, however, have introduced penalties which are a representative percentage of an organization's turnover, similar to GDPR fines. So there's a real mix in how the EAA is going to be enforced. And of course, that means that it's all the more important to work out which countries' rules do apply to you. And just looking into who will actually be monitoring compliance, that will be monitored at a national level by an established supervisory authority. It may be an existing one that's already monitoring other compliance with other regimes, or it may be a new one. There, again, are different approaches in each member state. So I'm just going to hand over to Michaela now just to talk about some practical steps to achieve compliance with the rules we've just mentioned.
Yeah, thanks, Tom. So let's start with some good news. Like we said, right? So the EAA is a directive, and the way the EAA is providing a technical guidance is through the EU standard called EN 301549, which includes all the technical aspects and the, for lack of a better word, instructions to comply. The reason why I announced this as a good news is that it basically reflects 100% the Web Content Accessibility Guideline in its version 2.1 and level AA. It's important to say that as the new Web Content Accessibility Guideline, so the 2.2 AA is already a recommended standard by the World Wide Web Consortium, most likely the standard EN 301549 will soon be updated to reflect the 2.2 instead of the 2.2 as a requirement. In general, the Web Content Accessibility Guideline is structured in success criteria that are distributed across the 4 main principles, which are perceivable, operable, understandable, and robust. That represent the main requirements for a digital property to be accessible to people to a variety of different abilities. The Web Content Accessibility Guideline is quite powerful because it doesn't provide a clear instruction on how to achieve things, but what needs to be guaranteed. And it is generic enough to make sure that pretty much all disabilities, in particular with the efforts that has been made with the definition of the new success criteria of the 2.2, and also considering combination of disabilities, which are happening very often. Can you go to the next slide? In order to achieve accessibility, I think it's fundamental to identify which are the best practices. The first thing that is, in my opinion, is one of the most important factors for success is making sure that it is clear that an automated testing is not enough to cover the entireness of the Web Content Accessibility Guideline, which means that an automated testing will not reflect your accessibility level. Consider that in the most updated version of the Web Content Accessibility Guideline 2.1 AA, none of the success criteria, and there are 50 success criteria, can be fully tested automatically. None. So the human intervention, the expert, where expert is somebody that understands accessibility and know how to test it, is essential in order to measure not just the conformance, but the accessibility of a digital property. The other items that is crucial to mention, and we are seeing in many of the use cases that we work with, is the trend of trying to itemize accessibility, so trying to define a checklist. Well, everybody that already started an accessibility program probably understood quite soon the importance of not just considering accessibility as a final check done at the end of a cycle. So it's not applicable a situation where I keep designing as I always did, I keep developing as I always did, and then I run an accessibility test at the end, and then I'll fix the few things that this test will highlight. Well, unfortunately, it doesn't work. This normally leads to a huge investment of effort, energy, and money with big impacts on timeline. Because very often, if accessibility is not treated as a requirement, it will result into a refactor rather than just a fix. So that's why we truly believe that accessibility actually needs to be addressed with enhancements and amendments on process, so the way the companies work. And this is in particular because maybe accessibility in the very first stage of your conformance journey can be a project. You have an existing digital property, you understand and you learn how many things you need to fix, then you start working on the fixes. But very soon, if you do not transform accessibility into requirements, if you don't gather all the competencies and experiences to understand how to handle the accessibility tests, the accessibility issues, and the accessibility requirements, you will just keep doing a ongoing round of fixes that will always be the same, with a very inefficient ways of working. Also considering connecting to what Sophie and Tom told us before, in particular in terms of the restriction that every nation part of the EU might apply to the European Accessibility Act, most likely nobody will touch the technical aspects. So nobody will try to adopt a standard that is different to the Web Content Accessibility Guideline. But for example, we are already seeing in Italy and France that there are more restrictive rules in terms of communicating what the company is doing. So for example, you might have the requirement of publishing on the website in your accessibility status your 3 years plan in order to improve and making sure that your commitment to accessibility will be ongoing. In Italy, for example, you need to provide a full list of non-conformances that are a result of a test performed by a third party. So these are typical restrictions that we will see together with the penalties and dissuasions that we discussed before. Bethany, can you go to the next slide, please? Yeah, if we consider, and I know that this looks like an oversimplification, but if we consider the generic software development life cycle, and we identify the 4 main phases, so with the design, with the development and definition of content, a test, and a release, every of these phases will be touched by enhancements that you are encouraged to implement in order to incorporate accessibility as part of your requirements. When we are talking about enhancements, we are also talking about all the preconditions to be able to implement these enhancements. It is easy to say that during the design phase, you will need to validate the accessibility goals, but that means that the design team will need to have all the competencies in order to do that. Or maybe you will need to rely on a partner that will hold your hand during this step, and maybe will provide you with training services, or will be the entity that will monitor and validate the designs. The same applies to the other 3 phases, but appears clear, I think, immediately that probably the biggest effort that companies will have to face is not just the remediation, but is the process, the work on process. And I think that the other message that should immediately be highlighted in this slide is that the misconception that very often we might hear that accessibility is just a development issue, is just a development responsibility, it is immediately rebalanced, right? So accessibility, if we are looking at accessibility from the angle we are trying to present today, becomes something that affects the entire organization. It is is related to the company culture, is related to clear requirements for every team. And only if everyone knows which are their own responsibilities in achieving a global accessibility for the digital properties, and everybody is aware about what who will come next to me, will have to do in order to guarantee accessibility, there will be an harmonization in working together in an efficient way that will most likely remove the cost factor from implementing an accessible way. It will be just the way we will work on our digital properties. So, as promised, let's review together a case study with Touchland. The challenge is very common to so many clients of ours. So, they tried implementing digital accessibility and complying with the Web Content Accessibility Guideline 2.1 AA. And they immediately understood how big was the effort required in order to do things in the right way. And in addition, with the European Accessibility Act coming soon and the limited internal resources, they were looking for a comprehensive solution to meet accessibility standards in the way they wanted, so in the right way, not just applying a patch. So the solution that Touchland adopted, thanks to our service, was through our fully managed service called UsableNet Assistive, that allows our developers to remediate the front end of the site, making sure that together with monitoring activities and that also use test automation, we have a pool of engineers and testers that are constantly validating every page and functionality of the site. And not only that, also the inclusion of the disabled community as part of a key actor to test and validate the work that our developers did. And this resulted into fixing everything on the site, from the navigation to the multimedia content, keyboard accessibility, low vision accessibility, and everything that you might think was required in order to comply to the Web Content Accessibility Guideline. And together with this, obviously, all the requirements require documentations in order to demonstrate the work that's been done, the investment that Touchland did, all the changes on processes, meaning that in this case, it's UsableNet applying this process of continuous monitoring and tests, once again, involving also the disabled community to guarantee a long-term compliance. And this obviously, needless to say, that improved the accessibility of the website, but also represented a strong shield against the legal risk, and obviously also meeting as a result the European Accessibility Act requirements, and increase the customer satisfaction and the business growth, as we need to consider that worldwide, around 20% of our customer base probably has a form of disability. Would it be a certified disability or a disability induced by the environment or the context of use? So in this slide, we would like to summarize which are the key 3 steps to start implementing the roadmap. The first one is understanding where you are. And the way you understand where you are is through an audit conducted by an expert. So somebody that can test against all the success criteria of the Web Content Accessibility Guideline and provides you with the number of success criteria that you satisfy versus the ones that you fail. Then the second step is all around with the results in your end, is understanding which is the action plan, which includes the prioritization strategy to implement, and I think that the interesting thing in accessibility is that the prioritization that we might be used to normally apply, so that might be prioritization in terms of severity of an issue, is not the only one. There are so many other parameters you might want to consider, in particular when you're approaching for the first time accessibility, that really depends on where you are. We have seen somebody prioritizing the resolution of the accessibility issues, not just by severity, but by the area of the page where the issues were occurring. This is because they have different teams handling different portions of the page, or somebody by different areas of the site, because there was one area of the site that was supposed to be redesigned soon, so the investment of remediating the area was not meaningful. Others prioritizing the importance of the flow and making sure that the main funnel of the site was as much accessible as possible. So there is work to do in terms of defining the perfect strategy. And then the third step is the continuous monitoring of the site and making sure that what you have achieved in the step before is not affected by all the activities, all the releases that you are doing. So making sure that the maturity that you are collecting while you work on accessibility is not invalidated by maybe a team or a third party that doesn't know enough and maybe deploys something that breaks weeks of work. I would like to also involve Sophie and Tom on this slide to share some thoughts and maybe their experience.
Yes, certainly. I think we can draw quite a lot of analogies, especially myself from a regulatory perspective, on compliance generally, because a lot of the advice I give is on this exact topic. It's not only working out which areas of the business, so for example, whether it's the GDPR, Digital Services Act, or something in between, it's working out which areas of the business are not compliant and which are. And as you say, Michele, it's not a one and done job. It's not something that can be done once and then be fixed and then never needs to be looked at again. And I think we, especially from a data protection perspective, have really kind of experienced that firsthand, where a lot of organizations thought that their compliance efforts were limited to a short and quick compliance roadmap, which ended in 2018. But actually, as we've seen, and your roadmap here represents this for the EAA, these things need to be consistently checked and reviewed. And it touches some of the questions actually that have been coming in about changing of standards, because, and it's a spoiler for our last slide where we talk about the fact that standards are subject to change. They are going to change, which is why we cannot carry out a single compliance exercise once and assume that we are compliant forever. We need to constantly be checking what the current standards are and how we map against them. And as you say, Michele, that extends to things like new features that we've introduced and how they affect our existing efforts. So I think talking, from the perspective of clients who've gone through this for other compliance efforts, there's always the expectation from, I think, particularly from a resource perspective, that this will only need a set budget, but actually it becomes a much bigger compliance effort than most people will anticipate. So yeah, talking about things that are subject to change. And as I was saying, the compliance standards are subject to change. And again, we've had some questions about this. Just to give you a couple of key takeaways, as we said, the next deadline is June 2025, the 28th of June, which is for all services and all new products which are in scope to comply with the rules. And a reminder that the fines and enforcement action that you could be subject to are being implemented in varying ways in different member states, which is why it's so important to really understand which rules apply to you and which products and services you need to make sure do fall within compliance.
Yeah, and in addition to that, as we mentioned very multiple times during this webinar, focus on making sure that accessibility is not just a one-off project, but is an ongoing routine. So involving test automation and obviously manual testing as part of your routine is fundamental in order to achieve full compliance and maintain it. And if you do not have the skills, the time, the resources to do it, rely on a partner that is not just a good partner in doing it, but is also a partner that can understand the way you work and can integrate in the most seamless way into your company processes, because you should expect by the partner that makes things easier for you, not more difficult. So somebody that really understands the way you work and supports you in the best way possible. And then, like we say, make sure accessibility is a requirement, so becomes part of your the development life cycle. There are many different ways to do it. Of course, spreading the accessibility culture within the organization is fundamental, but also consider to empower key roles into your organization as the guardian for accessibility. We have seen many companies that are working with us, because we recommended this to work a lot on enhancing the skills and the knowledges of the product owner, project manager team, and that was dramatically successful. So having somebody who's responsible for a on-time with quality deployment, also being responsible for a accessible deployment, was for many of our clients a key factor to achieve a higher and higher accessibility attention within the organization. All right, so I think it's time for the Q&A.
So maybe one thing I saw at some point, a question about whether this applies to the UK. Very good question. Short answer is no. The EAA has not been transposed in the UK because it was voted in 2019. So it was after the deadline that the UK had set for itself for implementation of EU law. However, we are seeing the UK doesn't have nothing. There are some existing laws, and also we are seeing a trend to, of course, catch up with whatever is trendy at that moment in the world of regulation. So watch that space. The UK is certainly not going to be left behind on accessibility, but it is not going to be the standard that is going to. Another question that I will quickly try to get out of the way, because I think it's interesting as well, was about a comparison between the US and the UK, and the US and the EU, excuse me. Someone asked whether it is possible to sue businesses that are non-compliant in the EU. And the short answer is that has not been the focus of the EEA. So that's the EEA itself is not built around the idea of having to go to court to get businesses to comply. It's mainly going through regulators. But with that being said, and so regulators are in charge of enforcing the text, and they will be the ones that are going to be potentially imposing fines. But with that being said, you always have in the EU normally anyone can, under the general theory of tort, you can, if it damages is caused to you, provided you can have sufficient proof to evidence this damage in court, you can always bring a claim. You also have some member states that have a specific mechanism to communicate with the agency or the supervision authority. So there's a special communication channel for organizations representing disabled people or consumers in general. So there are some special channels that have been created to help and to communicate, and that could potentially result also in in an action in court, but that's not the main focus of the EAA.
Okay, thank you, Sophie. Yeah, I think you answered like 4 of the questions that came in with those 2 answers, so appreciate that. I am seeing that question. I think it is a lot of companies that are familiar with the United States approach to accessibility and thinking it's going to be lawsuits. And I would almost more, and correct me if I'm wrong, but I would almost more compare it to the United States version of the SEC coming in and looking for employee personal insider trading happening. It's a regulator. It's not, it may not be a lawsuit like what we see in the US. It's more the example of the SEC coming in to find insider trading is the US comparable version. Is that right? Should I not? Okay, we'll just move on. We have a lot of questions, like I said.
So maybe one, Bethany, that I think is interesting is one question that was focused on the fact that we are expecting an update to the Web Content Accessibility Guideline 2.2 instead of the 2.1. So which are the risks of working on 2.1? And I can speak about the technical perspective, then maybe Sophie and Tom can also add some color from a legal point of view. The 2.2 adds a number of success criteria to the 2.1, and the main focus was to better define requirements for cognitive disabilities and motor disabilities. So it is important itself because it's not just an improvement of what was already part of the 2.1, but introduce some new aspect related to the community, so specific individuals. From a technical point of view, it would be important if we are considering the, let's say, the business aspect as a driving force to do an additional effort to comply with the 2.2. At the other end, and I'm only speaking based on the experience and things that we have seen, as the legal industry, also in Europe, the authorities that have the responsibility of checking the accessibility level of the website, at least in the initial stage, are relying a lot on test automation. I'm not saying that we'll always do that, but at the moment they are relying a lot on test automation. None of the success criteria of the 2.2 can be tested automatically. So in the short terms, I think that the exposure doesn't change a lot. In terms of strategy, I would recommend to consider the 2.2 as a phase 2 focus. Sophie, Tom, yeah, I didn't mean to give any legal advice.
No, I completely agree. Yeah, I saw a few questions and points being raised about the fact that we might have to, comply with one standard and then keep moving the dial as to what we comply with. And it's exactly as you said, we are expecting 2.2 to become the standard. There's a few questions as well about how we link the EAA to those standards. It's really contrived. Someone said there's no reference in the EAA to this specifically. You're right. It takes a lot of digging, but you can get there. The most concrete thing we've seen, which would indicate we're going to see 2.2 becoming the minimum standard to comply with, is a direction that was issued by the body which governs European standards. That was issued in 2018, which directed the standard to be updated, the standard being the one Michele mentioned, which incorporates the Web Content Accessibility Guidelines 2.1. There is a direction to update them by September 2025, which is very inconvenient because it's after the compliance deadline. But there's a direction to update it to reflect the requirements of the EAA. So what we're expecting there in this updated standard is not only for it to much more directly, and again, this speaks to one of the questions that was raised, much more directly map itself to how we can achieve compliance with the EAA's rules, but we would also expect it to incorporate version 2.2 of the guidelines. So there is definitely going to be a situation where there is a time when we have complied, we have a few more months, and actually the dial has moved and compliance is no longer the same kind of picture that it was 3 months ago. And I think that speaks to the fact that the EAA is heavily principles-based and wants to remain technology neutral to ensure that it doesn't fall behind as previous EU regimes have been. So I think, unfortunately, yes is the answer. There's going to be situations where we comply, the rules change, and we need to play catch up. But I would imagine in those cases, there's not going to be an overnight requirement to adopt. There will be grace periods because it would be impossible to expect that of organizations.
Yeah, and there was also, as part of the, this topic, one question was mentioning the 3.0 as the following update that we'll see. Not sure how many years we'll need to wait to see the 3.0, but the interesting thing is that the 3.0 will completely change also the compliance as a requirement. So the 3.0 will come together with the scoring mechanism that will most likely talk about accessibility in specific use cases rather than conformance and compliance. That might require significant changes to the technical documentation associated to the European Accessibility Act, so the EN 301/549. That, while it is true, is not mentioning the Web Content Accessibility Guideline 2.1 AA, is the carbon copy of the principal guidelines and success criteria. So we'll see what they plan to do, because the 3.0, which will be an accessibility guideline, no longer a web content accessibility guideline, will change everything.
I mean, I see another question that's relatively easy to tackle about whether that also applies for internal use of a company. So the EEA does not apply to something that is not aimed at consumers and the website, the digital services side. However, as Tom mentioned at the beginning of the presentation, the EEA is a minimum harmonization directive. That means it's a floor, not a ceiling. So you would be well advised to go and take a look at the laws of the country where that service is established, or the country that you're worried about, to check whether there might be something on top of what the EEA provides. I think that's helpful.
Okay, there's a question. In California, a bill was written and later died that held developers liable for accessibility, not the business owner. It seems that in the EU, something is happening that looks like teamwork. Can you speak to how companies have approached this with their developers? There is a cost for both parties to become and maintain compliance, and I'm curious about the conversations people are having.
Yeah, this is actually is a very interesting topic. I think is not mainly a liability issue, but is making sure that you are working with the right partners. So something that we recommend everyone, in case you are hiring a third party, you need to validate their honesty around their accessibility knowledges. So if I'm using a development third party, I would expect evidence of the test they did before handing off the product they made, the website they implemented to me. I would like to get from them references of works they did. I would like to also tie the contract to key performance indicators around accessibility. Maybe because you are making an investment, hiring a third party, validating their work, and if the third party finds violations of the accessibility guideline, at least you should not pay for the additional work for them to remediate. Other but similar scenarios can be considered when you are purchasing widgets that will be part of your experience in the website, for example, like the cookie policy banner, or I don't know, you are purchasing a checkout system. Yeah, make sure that they have a VPAT. VPAT is a standard that is very popular, is the Voluntary Product Accessibility Template. That is a sort of certification that of the accessibility level of the product that a company is delivering to you. This is a standard and a requirement for everyone that wants to work with the US government, but we are seeing many companies asking for that. That will immediately show you the maturity and the preparation of your third party. And these are just two advices.
Just on that point, my legal alarm bells are ringing, because obviously with any sort of outsourcing of a service or relying on a third party to tell you whether or not what you're doing is correct, as Michele says, there's a huge upfront exercise, your vendor due diligence, where you're working out, is the person that I'm onboarding honest and going to do the work that they say they're going to do? But on the other side, there also needs to be appropriate legal and contractual remedies if things go wrong. In terms of liability, and it's similar with many EU legal principles, it's going to sit with the organization to which the EAA applies. It's not going to apply to the external auditor who got it wrong. It's going to be the organization to which the EAA applies. It's going to be their responsibility to make sure they are appointing or outsourcing individuals or organizations which are trustworthy and which can vouch for the results that they provide. So very important to have some sort of remedy if things do go wrong as well from a legal perspective.
Thank you so much, Sophie. Thank you, Tom, for sharing your expertise with us today, Michele. And then that concludes this webinar.